Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Right. Normally, according to section 372 CRPC, we will be filing so many appeals when a person is not satisfied with the judgment given by the trial court. So he has got a chance to appeal the matter to the higher court. What is appeal? Appeal is nothing but a request to the higher court alleging that the lower court has not considered your case properly or the lower court has erred. They are not like that. Normally you go for appeal. So this appeal should be disposed as expeditiously as possible. Yesterday I discussed you regarding section 309 CRPC. As expeditiously as possible. Appeal, after all, appeal, what is the great thing in appeal? Only thing is basing on the judgment. No extra witnesses will be there. Only the depositions of the witnesses or the consideration of the judge. All these things will be discussed. At one stage, the appeal can be disposed of. Maybe 1 year, maybe 2 years. But please remember here, the appeal is lying for the past 12 years and already the convict or the accused person or the petitioner, Ritu petitioner has suffered sentence of 17 years, 3 months in jail. Yesterday, Honorable Supreme Court of India, taking into consideration of all these facts, immediately granted him a bail. He released him out, that's all. So once again, please remember Rudolph Shah case. So in that, Supreme Court has given a clear direction that if the person has already undergone more than 50% of the sentence period, he has to be released forthwith, that's all. Whether even on self-bail also we can release him. But still, this case is pending for the past 12 years. Right? So, this case is related to Ritu. You can read the case as Ritu Pal versus State of Uttar Pradesh in WP number 535 by 2021. Similar WP is there, that is Dharmendra versus State of UP, WP number 3642 by 2022. Right? Supreme Court on 25th of February granted bail to an accused, that is Ritu Pal, who has already undergone 17 years incarceration in Bihar jails. So this case was decided by Honorable Chief Justice of India, Sri N.V. Ramana, A.S. Bopanna and Madam Hema Kohli. Right. So here the case relates to 2004. In 2004, a murder case took place. Of course, it is a case which was registered under section 302, read with 34 IPC also. That means this accused, along with some others, he has committed the murder of the deceased. Of course, the regular process has gone. He was arrested. The other fellows were arrested. He was convicted in the year, I think, 2004. Then he was convicted of right, life into this is a life sentence, right? So he was convicted and ultimately maybe in the 2008 or so. Right from 2012 he has been in jail. Actually before conviction he was there for about 3 years. So actually after conviction 14 years 3 months. Before, if the trial, that if that period is also considered, he has suffered, he is in jail for 17 years and 3 months of the total custody. What more is necessary? So now it is very clear case of justice. So right to speedy trial is not followed. That's all. Simply to say, Article 21 says right to speedy trial is also a fundamental right. So here the appeal has been lying in the court, that is in the Allahabad High Court for about 12 years, not decided. Of course, reasons may be so many. It's not that easy. To comment is very easy, but there may be so many reasons. Advocate may not be ready, judge post may be vacant, the other person may not be ready, and routine adjournments would have taken place. Not ready, we request, and so many things will take place. It's not that easy. Very easy to comment, very difficult to assess. That's why the pendency is there. So similar type of case, that is Dharmendra versus State of UP, came before the bench of Sanjay Kishan Kaul. So he also lambasted the High Court and he has laid down certain parameters for the delay. Why so much of delay? He has stated that so a person who served for more than 14 years, according to 31 CRPC, he has to be sent away, even the appeal is pending. The appeal has to be decided. So, basing on the parameters like this, it has to be decided quickly if the person has already undergone 14 years of sentence. So, already you know that if it is simply life imprisonment, 14 years, that's all. But if the judge says life means till the end of life, we can't do anything. Then second, if the offender is not a repeat offender, recidivism, already I told you recidivism, that means if he is released on bail, he may commit once again an offense. So if that chance is there, okay, you can keep him in jail. Third point, he has already served more than 10 years. If he has been served with if the period of 10 years is gone, he has to be granted bail. Already, previously in Dharmendra case, Sanjay Kishan Kaul has given directions, and ultimately basing on that, Honorable Supreme Court Chief Justice of India released this person on bail because, of course, giving a direction to the Allahabad High Court or State of UP to dispose the appeal as early as possible, as soon as possible. So friends, these types of cases, what do they say? They reflect upon the judicial system, the delay in the judicial system. But delay, the reasons may be so many for the delay, but delay is a delay. A person, it's not that easy, or he is suffering mentally being in jail for so many years. What is the solace for him? So we have to remember V.R. Krishna here. Bail is a right and jail is an exception. In exceptional circumstances only, he will be in jail. In the last video itself, I told you that the overcrowding of prisons, yes, with such people, what is the use except overcrowding? Nothing more will be done. So please remember, if such type of cases come to your knowledge, definitely you have to appeal before. You can even file a writ petition also, just like Rudolph Shaw case, you can file a writ petition and see that the innocent persons or the persons unnecessarily kept in jail, they are brought outside. Definitely this case will help you in protecting the innocent persons. I hope like that. Thank you very much.